are organized by the Joint Jurist Journal. Before we start, I request you all the participants, please keep your microphones and cameras turned off so that the session can run smoothly. Also, please stay with us till the end because we will share a feedback form in the end of the session. Filling out this form is mandatory to all if you want to receive your participation certificate. Now, it is my absolute honor to welcome our guest speaker for today, Advocate Arun Kumar Sir. Sir is a practicing advocate at Delhi High Court and also the founder of the law fiction law firm. Thank you so much, sir, for taking your valuable time for us today. We are very excited to learn from you. The platform is all yours. Over to you, sir.
Okay, we should thank you to you. Hello, am I audible?
My pleasure, sir. Yes, sir. My
Yes.
pleasure, sir.
Good afternoon, distinguished members of the Joint Jurist Journal, learned colleagues, insolvency practitioners, fellow advocate, and students. Am I audible?
Yes, sir. You are audible, sir.
Very good. It is an honor to address this August gathering today on a subject that sits precisely at the emotional and structural core of India's evolving insolvency regime. The delicate balance between the commercial wisdom of the CoC and boundary lines of judicial review by the NCLT. Before we jump into the statutory mechanics, let me ask a show of hands of a quick text in the chat. How many of you believe that the CoC has become too powerful under the current ecosystem? Anyone? So to set the context of where my perspective come from, let me briefly introduce myself and our practice application. As a founder of the Lawfication, my day-to-day work bring me directly before the NCLT and NCLAT, having sat across the table from a legally represented almost very single major stakeholder class under the IBC, ranging from insolvency professionals and financial institutions to operational creditors and home buyers. I have seen this legal tug-of-war manifest in real-time litigation. Every time a resolution plan is approved or rejected, someone feels aggrieved. The financial creditors claim commercial supremacy. The left out stakeholders claim a violation of natural justice. Today, we look at how the law harnesses this clash. Let us step back for a moment and look at the fundamental paradigm shift that the IBC brought to our economic framework. Before 2016, India's insolvency framework was plagued by delays because debtors stayed in control while defaulting on debts. The IBC completely flipped this script to a creditor in control model. It created a dual engine machine. The CoC drive the vehicle using its commercial judgment, while the NCLT acts as the structural guardrail to ensure the vehicle stays on the lawful track. Think of it as a high stake corporate turnaround. The owners have failed. The creditors step in temporary stewards to rescue the business enterprise, not just to recover money. This brings us to the core dilemma that we are unpacking today. This is the question that keeps corporate lawyers awake at night and keep court docket full. Can the NCLT second guess the CoC? On the one side, financial institutions argue it is our money at risk, so our business judgment should be final. On the other side, aggrieved parties argue we need judicial interview to prevent arbitrary behavior. To understand this conflict fully, we must first define exactly what constitutes commercial wisdom under the code. What do we mean when we say commercial wisdom? We are talking about pure business calls. Who gets paid how much? Is a practical bidder capable of running a steel plant or a real estate company? Should we give the process another 30 days or pull the plug and liquidate? These are not strict legal calculations, they are commercial trade offs. The rationale for giving this power to the creditors instead of judges is grounded in institutional competence. The underlying logic is straightforward. A commercial court judge, no matter how brilliant in corporate law, does not track market demand cycle, raw material supply lines, or haircut risk. Daily financial creditors are risk bearers whose balance sheets are directly affected. Therefore, the law trusts their financial assessment over judicial instincts when determining if a corporate debtor can be saved. Let's see how the legislature built this conceptual rationale directly into the statutory provisions of the IBC. The statutory equilibrium is cleanly preserved between Section 30, Clause 4 and Section 31. Under Section 30, Clause 4, the CoC votes on feasibility and viability once approved by a 66% majority. The plan travels to the adjudicating authority under Section 31. The NCLT's review is focused on ensuring the legal pillars of the code are intact. Now that we understand the statutory blueprint, let's trace how the Supreme Court of India and solidified this framework through landmark judgments. Our journey into case law begins in 2019 with K. Shashidhar versus Indian Overseas Bank. This is where the Supreme Court drew a clear line around the CoC. The court stated clearly that the decision of the CoC to approve or reject a plan is completely non-justiciable. The NCLT cannot say Plan B looks slightly better for the local market, so let's reject Plan A that is off limits. While K. Shashidhar closed the door of reviewing plan rejections, the celebrated SR Steel case settled the question of the fund distribution. If K. Shashidhar is the foundation, SR Steel is the absolute pillar of IBC commercial wisdom jurisprudence. In this mega insolvency case, the Supreme Court confirmed that the CoC has wide discretion over how funds are distributed across different stakeholders categories. Unless you show a direct explicit violation of the law, the commercial choice of the CoC stands firm. Lenders often decide to pay themselves a higher percentage compared to operational creditors due to their secured status. SR still protected this commercial choice from being raised by the NCLT on purely sympathetic grounds. Next, the Supreme Court addressed whether a plan could be thrown out simply because the numbers didn't match the initial liquidation value. In the Maharashtra Seamless ruling 2020, the Supreme Court addressed a common source of friction. What happens when an applicant's bid is lower than the liquidation value calculated by the registered valuers? Objectors argued this was an undervaluation. The Supreme Court clarified if the CoC evaluates the market reality and concisely accepts the bid to keep the company running, the NCLT cannot reject it based on the mathematical valuation models. This emphasis on non-interference was re-emphasized during the post-pandemic period in the Kalpras Dharmshi case. In 2021, Kalpras Dharmshi served as a strong reminder from the Supreme Court to Appellate Tribunal. The court observed that the tribunal often step into the shoe of the commercial decision makers by trying to access timelines, bidding procedures, and comparative viability. The Apex Court firmly pulled back the reins, stating that minimal intervention is necessary to maintain speed and certainty. But this raises an important question. Is the COC completely uncheckable? The answer came in J.P. Kingston's judgment. Now we look at the vital turning point in our discussion. J.P. Kingston, here the Supreme Court balanced its previous decisions by clarifying that commercial wisdom enjoys supremacy but not complete immunity. In the COC approved a plan that runs roughshod over procedural mandates, treats a class of stakeholders with clear unfairness or breaks a law, the NCLT is fully empowered to step in and stop it. If a plan fails to allocate the mandatory minimum payment due to the operational creditors under the law, the CUC cannot claim commercial wisdom to shield that mistake. That plan is legally flawed. To see how far this commercial supremacy extends, let us look at the Shiva Industries case regarding withdrawals. In 2022, the Supreme Court extended this proactive umbrella to Section 12A settlement withdrawal in Vallal RCK versus Shiva Industries. If 90% of the lenders decide that settling with the original promoter and pulling out the CIRP is the best financial move, the NCLT cannot refuse the withdrawal by saying, no, I think a public auction will yield more money. The lender collective choice control the exit door as well. Let us consolidate these landmark judgments into a clear summary framework before we look at the specific limits of the NCLT's powers. These, uh, these metrics serves as your operational cheat sheet for litigation. It tracks the evaluation of the doctrine from establishing non-justiciability in K. Shashidhar to giving control over distribution in SR Steel, protecting low-value bids in Maharashtra Seamless, defining boundaries in J.P. Kingston, and finally covering settlement exists in Shiva Industry. This summary shows a steady judicial commitment to supporting creditor autonomy while preserving clear statutory boundaries. Now let us examine the explicit boundary lines by addressing the limits where commercial wisdom ends and judicial intervention begins. If there is one phase you should take away from today's session, it is the commercial wisdom enjoys supremacy, but it does not enjoy immunity. The NCLT is not a rubber stamp, it functions as a legal screening filter. If a plan passes the commercial test but fails the legal test, the court has authority and the duty to stop it. Let's break down the four specific grounds where the NCLT can exercise its review power, starting with compliance under Section 30, Clause 2. Ground number one is Section 30, Clause 2, the most frequently invoked statutory check. The NCLT must look at the plan and check of these mandatory requirements. Are insolvency costs paid first? Are operational creditor given their legal minimum? Is there a clear plan for who will run the company tomorrow? If any checkbox is empty, the COC's commercial wisdom cannot save the plan. As a practitioner drafting or reviewing a plan, treat Section 30 Clause 2 a non-negotiable compliance list before the plan ever goes to a court. The second ground for intervention involves procedural errors during the process. Insolvency resolution is highly time sensitive and strictly regulated. If the resolution professional or the COC commits a material procedural error, the final product becomes legally unvulnerable. For instance, if a major financial lender was improperly excluded from a voting session, or if notice were compressed below statutory minimum without approvals, the NCLT can intervene to fix the process. Beyond simple process mistakes, the court will step in if there is evidence of bad faith or fraud. Fraud unravels everything if there is evidence of collusion, such as dominant creditor working behind the scenes with a bidder to squeeze out small stakeholders, or a backdoor attempt to reinstate an ineligible promoter under Section 29A. The commercial wisdom argument fails completely. The NCLT retains its inherent power to prevent abuse of its own processes. The final major ground for intervention is the violation of the principle of natural justice. While the SR Steel case confirms that the COC can decide the final distribution split, it does not give them permission to be completely arbitrary. If a resolution plan completely zeroes out operational creditors while the company is an active going concern, or treats similar creditors within the same class differently without a rational basis, it risks being struck down for violation natural justice. Having examined both sides of the coin, let's step back and look at how this relationship has evolved over years. In the early years of the IBC, NCLT benches often intervened on the equitable grounds to give promoters extra chance or adjust distribution metrics. This activism showed down resolution timeline. Recognizing this, the Supreme Court pulled the pendulum back toward judicial restraint. Today, the prevailing rule is clear: look to the text or the code and protect the speed of the process. This brings us to that what I call the real clash under the insolvency regime. We often talk about this is as a clash of supremacy, but it is actually a search for structural equilibrium. If courts interfere too much, resolution timelines collapse and assets degrade. If courts stay out entirely, minor stakeholders can be marginalized. The IBC's solution is a clear division of labor. Commercial choice belongs to the COC. Legal gatekeeping belongs to the NCLT. Allow me to share my professional perspective on how this system operates in practice. In my view, the Supreme Court was right to establish commercial wisdom as a foundational rule. However, we must not let it become an excuse for arbitrary decision making. The goal is neither creditor supremacy nor judicial supremacy. It is a resolution supremacy. Every stakeholder, creditor, resolution applicant, professionals, and judges must focus on preserving the business enterprise. Let us move toward the practical portion of our webinar by reviewing common mistakes made during litigation and operations. Let's translate these legal concepts into operational guidelines, starting with the pre-voting phase. First, the resolution professional must act as a strict gatekeeper under Section 30 Clause 2. Second, when the COC meets to discuss plan, they shouldn't just record the final vote. Their minutes should explicitly detail why they consider a plan viable or unfeasible. This contemporaneous record is very primary defense if the decision is challenged in court. Next, let's look at the key takeaways of the fund distribution and voting phase. When moving to the voting and distribution phase, the COC must ensure that variations in payout across different creditors classes are supported by clear rational justifications. Additionally, keep a close eye on your voting math. A standard plan requires a 66% majority under Section 30 Clause 4, while a Section 12A withdrawal needs a 90% threshold. Finally, always confirm that the plan explicitly protects dissenting financial creditors by matching or exceeding their liquidation value entitlement. Let us conclude our takeaways by looking at the final approval phase before the NCLT. In the final NCLT approval stage under Section 31, focus your argument strictly on legal compliance rather than trying to pitch the economic merits of the plan. Show the court that your process was transparent and that minor stakeholders were given a fair hearing. Remember, once the NCLT signs off, the plan becomes immediately binding on all parties, including state governments, tax authorities, and employees. To help ensure a smooth approval process, let's look at common pitfalls that practitioners frequently encounter. Let's review four common mistakes that frequently lead to plan rejection or lengthy appeals. First, recording simple voting without documenting the commercial reason behind the decision makes the resolution vulnerable in court. Second, failing to pay insolvency costs or operational minimums. First, violates clear statutory rules. Third, rejecting a viable plan simply because it falls below an arbitrary liquidation value estimate is an unnecessary mistake. Finally, ignoring minor or operational stakeholders creates easy target for natural justice appeals that can derail the entire timeline. Now let's look at actionable strategies to avoid these mistakes and protect your insolvency proceedings. Here are four practical tips for insolvency professionals working in this space. First, maintain an exhaustive administrative record. Your minutes are your primary defense in court. Second, the resolution professional must remain strictly independent and avoid appearing biased towards specific financial lender. Third, runs comprehensive Section 29A eligibility checks early in the process rather than waiting until the final vote. Finally, use transparent distribution table to clearly demonstrate to the NCLT that all statutory minimum payment have been fully covered. Let's wrap up our presentation by addressing frequently asked questions that arise in courtroom litigation. Let's address two common questions that regularly come up in insolvency disputes. First, can the NCLT change the distribution mix on sympathetic grounds? The answer is no. SIS still settled this. The distribution mix belongs to the COC as long as it respects the statutory minimums. Second, is the COC forced to accept the highest economic bid? The answer is no. Lenders are fully entitled to reject a higher financial offer if they believe the bidder lacks the operational capability to keep the company running long term. Let's look at our next set of frequently asked questions regarding valuation and settlement exit. Can the NCLT throw out a plan simply because the bid falls below the calculated liquidation value? The answer is no. Maharashtra Seamless confirmed that the market reality assessed by the CoC overrides abstract valuation numbers. Finally, can the code block a Section 12A settlement withdrawal because it prefer an auction? Now, again, answer is no. Shiva Industries established that a 90% CoC decision to settle and exit falls uh, within their protected commercial domain. Let us summarize our final conclusion as we wrap up today's keynote presentation. To conclude, let's remember that the Insolvency and Bankruptcy Code is an economic reform designed to preserve corporate value and save businesses, not a simple debt recovery tool. Neither the CoC nor the NCLT is supreme in isolation. Both are indispensable parts of our insolvency ecosystem. The success of India's corporate rescue framework relies on maintaining a harmonious balance between commercial wisdom and judicial review. With that, I want to thank you all for your time and attention and open the floor for your questions.
If anyone have any questions, queries, please directly ask to the sir. Kindly turn on your mic. I think, sir, no one have any queries.
Okay, Suraj.
Yes, sir. So, sir, thank you so much, first of all, and for sharing your valuable knowledge and time with us today. It was a really wonderful session. And thank you once again. And thank you for all the participants who joined us for today for the webinar. And the Google feedback form will be shared. And please kindly fill the form to get your e-certificates. It is I shared. Okay. Kindly fill the Google form. And thank you, everyone.
Okay,
Have a
thank you,
great day.
Suraj.
Thank you so much, sir.
Thank you, Suraj. Thank you once again to the organizer of the Joint Jurist Journal and all of you for your participation today. Thank you very much. Thank you, Suraj, for providing me this opportunity.